Civil rights lawyers protect something that we all love. We all love the Constitution. It's a beautiful document. We're all aware, especially nowadays, of our rights, our First Amendment rights, our Second Amendment rights. So it's very important to protect those rights. To me, being a civil rights attorney, you're protecting everybody's rights. You're protecting the community. And there's very few of us that do it well. There's very few of us that want to do it. They're very difficult cases. I like challenges. So I like making new law. I like making changes. One of the problems clients have that we have to deal with and work with them is when their civil rights are violated, what civil rights are protected, and what causes of action do they have, what remedies do they have. So your civil rights come from your federal constitution, your state constitution, which varies slightly from state to state, and also laws that are passed. And we're proud in that we've made changes in laws because of our work in civil rights. How do civil rights laws in Louisiana differ? We have the Napoleonic Code, and there's a lot of confusion, over that. Your federal civil rights, or Section 42, 1983, the Federal Civil Rights Act, is the same all over the country. There's some little differences, state law, like on your prescriptive period or something like that. It's 1 year in Louisiana. And then you've got state civil rights laws. So you have to look at all of those together. When I was a baby lawyer, I cut my teeth on civil rights cases. That was the first cases I went to trial. Didn't always win back then, didn't always know everything I know now. Got my head bashed in the concrete, but I learned. And then I got better and better. I have several record judgments in civil rights cases, a whole record for First Amendment cases, and like I said, in tasers, police cases involving shootings, excessive force. We've done a lot of those. I grew up doing those. Client communication is very important. I think that's one of the biggest complaints of clients, is that their attorney doesn't call them back or respond to them. And they're right. We don't do that. They got my cell phone. They can call me anytime. We have to do that, because if you get crippled by the police, or you get in an extensive motorcycle accident, or a loved one's killed, we've got to react right now and preserve that evidence, preserve that case. We really work our cases. We're really choosy on what cases that we pick. We look for cases that are going to make a difference in the community, that are going to protect the community. And we work those cases extensively by doing focus groups and other novel research methods. So when we go to court, we've tested every exhibit, we've tested all the witnesses, we destroyed all the defenses, and we can predict pretty closely, with pretty close accuracy, what that outcome is going to be. We at the law firm of Glenn C. McGovern are a small law firm. We're tightly knit. I love it when I go to trial and they've got 6 lawyers on the other table and it's just me. It's like David and Goliath. And usually they mess up because they've got so many people and they make mistakes. We've got Peyton Bowman here, Callan Johns, myself, 3 lawyers, and then we got support staff. And we work tightly together. We've been working together for years. And I think having a smaller law firm and reducing the number of cases, we're not overloaded with cases. We can spend more time with the client and with each case, and we get record results doing that. Civil rights cases are very complicated, so a lot of the times the client says, well, what do I do in my initial evaluation? Just call us up, give us the basic information. We'll get whatever documents you have, come on in, and that's another area where they're so complicated, we need to meet with the client and see if we can work with that client. We've got to work like a business partner or a spouse or whatever together, because they're very difficult cases, and get all the information. And they've lived through this event, we haven't. So we need them to work with us to get all the information we needed to successfully win that case and beat qualified immunity or the other defenses, comparative negligence, for example.